Good evening, Judge Kingsburg and fellow jurors. I'm coming to give my opinion on the case of Ashford University versus Alicia Astroth in the case of her HIPAA rights being violated. In my opinion, um, based on the meaning of HIPAA, it is a statement that was put in place to cover a patient rights and medical information up under the law, where anything cannot be disclosed unless the patient give consent. Well, in this case, Alicia Astroth is stating that her rights were violated and her records were given to the court judicial system without her permission. In that case, they were not violated. Reason being is because if your medical records are subpoenaed by the court, and it's going to help what your case is about with, however, what is going on. The only way they would know that you have went to that doctor's office, you had to tell them that you received medical treatment or some type of medical assistance from that facility. So that gives them the right to go after every medical facility that you have visit to get your records. So therefore, if it's court order and it was subpoena, they have their right. And based on the rules and regulation for HIPAA, when it comes to dealing with your records being submitted to or shared with other people, the court order excludes them from being in any type of violation for disclosing your information. Um, a subpoena is something that is issued by someone other than a judge, such as a court clerk or an attorney in case, or something different from a court order. A HIPAA provider may provide or disclose your information to the party issuing the subpoena only if the notification requires of the privacy rules are met. And in this case, they were met. Like I said, they wouldn't have known that this client, that Alicia actually went to Ashford University, had she not disclosed that information. So therefore, if the anything pertaining to what they're asking for, that's what they're allowed to give. They can't give the whole full entire medical record. They have to only give what is specified. And once you give whatever information is specified, then therefore they can move forth with their case if it's going to help the case in any kind of way. And so, in my opinion, I don't think that the defendant should be held liable for violating the patient rights, because the court system wouldn't have known that this client went there. So, in other words, I am ruling in favor of the defendant. They followed the proper procedures, the proper protocols. They notified the client with a certified letter letting her know that her records were being subpoenaed by the court system, and what reference of why they were being subpoenaed. All they know is that they got a letter saying that they need records from this date listing this type of information. So as long as specified information was disclosed in there, and the information that they needed only for the dates of services or whatever time frame that they're looking for, as long as they released that particular information and not the entire medical record unless they specify it, then the defendant, Ashford University, did their job. They did their part. So, and by law, they were covered because of them being in the judicial system. They are not liable to be penalized for releasing medical records that were subpoenaed. So, in this case, I don't think, and I believe that Ashford University didn't do anything wrong. All they did was follow proper protocol and procedures based on a subpoena that they received. Because by law, had they not released the information, then charges could have been filed against them. Because the court system has the right to get those records by any means necessary. I know this firsthand because I work in medical records at my current position, and I have to pull medical records on a daily basis. And we have subpoenas that are given to us on a daily basis. And when they subpoena us to give records, we have to send the records. So, in therefore, the defendant followed the proper protocols and procedures. And I believe that they should not be held liable or sued because the client feel that her rights were violated when they were not violated, because she gave a verbal consent, basically telling them that she received services from this medical facility. So the defendant did nothing wrong. Thank you.